possessing somewhere between 3.5 and 100 grams. That substance being, as this is charged as unlawful distribution of methamphetamine, you're looking at a level 3 drug felony. That means if you were to be convicted, depending on your criminal history, if any, you could have to serve at least 55 months up to 247 months in prison, and you could pay a fine up to $300,000. On count 2, you're looking at conspiracy to distribute an unlawful substance, methamphetamine, another level 3 drug felony, which means you could serve another 55 months up to 247 months in prison, and pay another $300,000 fine. In count 3, you're accused of possessing a certain quantity of methamphetamines, approximately 59 grams, to which the drug dealer tax stamp is required to be affixed, and you did not allegedly have that. This is a level 10 person felony. If convicted, the fine or the penalties could be up to 5 to 13 months in prison and $100,000 in fines. In count 4, you're accused of trafficking and contraband in a correctional facility. The state's alleging that you did unlawfully and knowingly, without the consent of the administrator of a correctional institution, have in your possession, while in that correctional facility, 12 grams of methamphetamine. This is a level 6 non-person felony. The sentence could be 17 to 46 months in prison, and the fine could be up to $100,000. In count 4, you're accused of the crime of forgery. That is unlawfully and intentionally possessing with intent to issue or distribute a written instrument, knowing it to have been made, altered, or endorsed, or possessing and using a fake identification. As charged, this is a level 8 non-person felony. It carries a sentence of 7 to 23 months in prison and a fine up to $100,000. In count 6, you're accused of identity theft, personally possessing an ID, a Kansas driver's license, belonging to, using it as fake identification for yourself with the intent to defraud that person or someone else. This is a level 8 non-person felony. The penalty could be 7 to 23 months in prison and up to a $100,000 fine. In count 7, you're accused of interference with the law enforcement officer by intentionally and knowingly concealing, destroying, or materially altering evidence with the intent to prevent or hinder the apprehension or prosecution of a person, to wit, throwing guns and bags containing methamphetamine out of a moving vehicle. As charged, this is another level 8 non-person felony, meaning to your sentence could be added another 7 months up to 23 months in prison and another $100,000 fine. In count 8, you're accused of interference with law enforcement by knowingly providing information to an officer that you knew or should have known was false, with the intention to influence, impede, obstruct the officer.
Right from the opening seconds, you can feel the weight in the room. This isn't a minor possession charge. It's a laundry list of felonies, each carrying years behind bars. The judge's tone is clinical, but the stakes are massive. For viewers at home, this is where reality smacks harder than any TV show. Each number, each count is a potential life-altering sentence.
It's a Class B non-person misdemeanor. If convicted, it would not carry prison time. It would carry up to 6 months in the county jail and a $1,000 fine. Because of the felony charges herein, Ms. Denny, you will be given a preliminary hearing, but before I set that, are you going to hire an attorney or apply for court?
I am actively looking into lawyers.
So you believe you're going to hire your own attorney?
Yes, ma'am.
And you believe you have the means to do so?
Yes, I've actually also been looking for a job and actively getting into drug and alcohol assessment and treatments.
Do you think you need to apply for court-appointed attorney? And if you do you wish to do so now?
I would like to be given a little bit more time to look for an attorney, my own attorney, before going for court appointed.
All right, so you don't have a job. Do you have any money?
Not right now. I mean, my mom's been helping me a lot, but
All right, so your mother is able to help you get an attorney?
yes, ma'am.
And you've talked to her about that, and she's willing to do that? Out that you're not able to hire an attorney by your next court date, you can always come in, and I'd urge you to come in and get an application for court-appointed attorney well before your next hearing date. Please do not put that off. All right, so Missy, she's going to hire an attorney.
April 26th at 1:30.
You and your attorney will need to be back here April 26th at 1:30, and that will be by Zoom. So either bring in your hired attorney or be waiting to meet your court-appointed attorney. Again, do not wait. You've made bond, it looks like.
Judge, there's a motion to revoke the defendant's bond filed on record.
Listen closely here. She's trying to present herself as someone who's turning her life around. Looking for a job, getting into treatment, asking for time to hire her own lawyer. But the judge isn't just asking about attorneys for paperwork reasons. He's probing whether she really has stability or if this is just lip service. This tension between her words and her history is what makes courtroom moments like this so gripping.
Judge, one of the conditions of her bond is to not be having contact with her co-defendant, Mr. Goodwin. If you look at the bond in this matter, it says no contact with Tyler Goodwin specifically in the mid-range of the bond in the special conditions section. It also says no contact with co-defendants in the pre-printed information. And Ms. Denny was arrested on January 30th. In this case, she bonded on a bond of $47,500 on February 4th.
Say that amount again, please.
$47,500.
And she posted that bond on February what?
On February 7th, 3 days later, she was found with Tyler Goodwin in Butler County, Kansas. She was arrested for interference with law enforcement operating a motor vehicle without driver's license. That is in Butler County Sheriff's Office case 2024-00001811. Ms. Denny gave officers her adopted sister's name with the wrong date of birth. She did not match the photo.
That's the second time around. That's not the same time I've just gone over with her.
Stopped by Butler County, and they were trying to push a 2013 Lincoln MKX out of the ditch. She admitted she had been driving, that she knew Ms. Mitchell had a valid license, so she gave Ms. Mitchell's information to the Butler County officers, and she was taken into custody for interference. Technically, she could also be charged for identity theft if Ms. Mitchell didn't consent to the use of her name. And Ms. Denny did so to avoid the fact that she did not have a valid driver's license and that she had been the one driving. She was booked into the Butler County Jail. The affidavit from Billy Cole of the Butler County Sheriff's Office is attached to our motion. And the co-defendant, Mr. Goodwin, was with her at the time that she was.
This is the hammer drop. Only days after posting a $47,500 bond, she's caught with the very co-defendant she's forbidden to see, giving a fake name to law enforcement and pushing a car out of a ditch. It's the kind of self-destructive spiral you often see in high-stakes criminal cases. A total clash between core conditions and street reality.
Contact with co-defendants directly or indirectly, but is specifically written in here, no contact with Tyler Goodwin. And she has had ongoing contact with him. We have witnesses here today. They've continued to have ongoing contact, and she was arrested in Butler County with Tyler Goodwin. We have attached the affidavit of Deputy Billy Cole. He is with us today. And responded to a subpoena when you set this yesterday. We got right with Deputy Cole so that we could get him on here by Zoom today. And she was booked into the Butler County Jail operating a motor vehicle. So our request is that she have her bond revoked for having ongoing contact with Mr. Goodwin and continuing to commit more crimes. Not only was she arrested there for interference with law enforcement, she also had no valid driver's license. Crimes that have been committed over in Butler County, as well as the ongoing contact. The witnesses stand ready to testify.
Very well. Mr. McClendon, does your client contest these violations and wish to have an evidentiary hearing?
Not to my knowledge, no, Judge.
All right, then let me visit with you, Miss Denny. Do you deny these allegations and wish to have an evidentiary hearing wherein Miss Gillette would have the responsibility of putting on witnesses if she can and showing these alleged violations?
No, Your Honor.
So you do agree that these violations took place as alleged, making you enter this admission today by any threats or promises? And do you understand that if I accept these admissions, you could and probably would have your bond revoked? So you did have ongoing contact with Tyler Goodwin?
Yes, Your Honor.
And you were booked into the Butler County Jail for driving without a license.
Notice how quickly this part moves. She waives her right to an evidentiary hearing and admits the violations on a record. No excuses, no fighting it. It's like watching the air go out of a balloon. In that moment, you can sense that she knows what's coming next. Bond revocation and jail.
And assessments for those facilities.
She has some very serious charges, multiple charges, like 8 felonies, 1 misdemeanor, and her bond was set at $47,500, made by Big Fish Bill. With that, I'm inclined to make her bond. I'm going to make her bond $90,000, cash or surety required. No contact with Tyler Goodwin while they're in the jail, while one of them is out of jail, under any circumstances. No contact. Don't write, don't social message, don't pass notes, don't tell someone in the jail to give each other a message. Facilities. Do we have a hearing set for her?
We do. Her hearing's April 26th at 1:30.
Yeah, I just got appointed to this case yesterday, so I haven't even received discovery. So
All right.
that's where I'm at on that.
Sheriff Samuels, if you would please have you or your assistants take Miss Denny into custody, please.
Judge, are you going to require GPS or not?
Yes,
Just so
yes, GPS. I meant to say that. That was the other thing I meant to say. GPS, no contact, no violations of the law, standard conditions. Sheriff Samuels, can you hear me? Missy, can you contact someone to take her into custody down there?
He may have walked over to the courtroom.
All right. Miss Denny, do you have an officer there with you now?
No.
Yeah.
Okay. All right. She needs to.
And here's the climax. The judge doubles her bond to $90,000, orders GPS monitoring, and instructs the sheriff to take her into custody immediately. This is a textbook example of how fast things turn in court. From appearing on Zoom with a shot at freedom to being physically taken into custody minutes later. It's a sobering lesson for anyone who thinks bond conditions are optional.